we initiate chaos. Theory guarantees that we'll play like lightning shots, sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now. They see the world keeps trying to shake us. It only wakes us. The pendulum swings. The pendulum swings. It's in a beautiful darkness. Only another. It's full steam ahead. Full steam ahead. All about the petty express. Misdirected from the start. It's a runaway train. Come a freight train. I come a freight train. In a beautiful darkness, the petty express. In a beautiful darkness.
Well, you guys, it's going to be a shorter day today. While we were anticipating that the defense was going to rest today, it seems like they maybe didn't communicate that desire to the judge. So we are basically losing a day. But let's see how the shenanigans unfolds.
Please be seated.
You want? In the matter of the Commonwealth versus Brian Walshe, Norfolk Indictment 2023-0091, continuation of jury trial. Counsel is present in court. Counsel starting with the Commonwealth. Kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning.
Good morning, Your Honor. Ann Yas for the Commonwealth.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Good morning, Your Honor. Larry Tipton for Mr. Walsh.
Morning. We need the defendant.
I was wondering why Brian wasn't there, and I thought we were just all receiving an early Christmas miracle, and he stayed home, or, well, his home in prison, or jail, whichever one. Oh, he has a suit.
Your Honor, for the record, the defendant's present in the courtroom.
Thank you, Madam Clerk. All right, at the close of yesterday's day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not? All right. Does that moot every issue that I researched last night?
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is the defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately.
Well, okay, here's the problem. The defense, this could be, as someone said in the chat, UK Anton, hey, we're being spared to have to listen to, Brian. Defense Diary said on Twitter this was a great move for the Commonwealth, but Melanie Little said that it reflected that the defense thinks that the Commonwealth failed. And I can see both ways. I can see that the defense has just conceded that there is no way that any reasonable person could buy their defense, or they could be thinking that the state has proved something, maybe second degree, a heat of passion murder, but not the, necessary premeditation that would get you to a first degree intentional murder. So I can see it both ways. Both of those lawyers are much more educated in law than me. So I do like that even with people with the same degree, there are different perspectives, and they both could be pointing out very different things. And The fact is that, you know, a jury could agree with both of them. So basically, what just happened is that the defense had put up, I guess, a motion with 5 separate issues that were possibly going to be coming up if Brian Walshe took the stand. And the judge had researched over the night to kind of address those 5 separate issues that were put in, that the defense said might be, you know, something that they would have to deal with should he testify. However, the defense has now told the judge, and she did seem a little bit irritated that she had just spent the entire night researching these 5 different motions. Basically, the defense is going to rest. Now, the judge is going to have the colloquy or the speech, the kind of dialogue with Brian, where she basically goes through the standard, you understand that you're not required to testify, all that jazz. So that's where we are right now. Now, this is outside the presence of the jury. This is right when they come in, you know, to do the kind of like, this is the things we need to discuss today kind of meeting.
After the rest of the day. Let me just put in the record. The Commonwealth previously, and I ruled on this at the side of the bench previously, the Commonwealth previously asked this court to exclude the defendant's plea of guilty. And I guess the only way that would come in at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously. I want to put in the reason why I excluded that testimony now. The Commonwealth did file a motion in limine to exclude evidence that the defendant pled guilty to misleading the police into Anna Walsh's disappearance and improper disposal of her body. After consideration, I allowed and still am allowing the Commonwealth's motion for 2 reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I specifically acknowledge that I read this morning the defense's motion to admit the evidence of his guilty plea, which has been docketed as 216.
So again, why is the defense now making this motion to allow the evidence in? Is this defense just... I have no idea where this defense is going. Not that it makes any point at this, not that it makes any point at this point since Brian's not testifying, but what the hell is this defense?
That was filed on December 11th, 2025, this morning, I believe. I have read it, but it doesn't do anything more than to set forth the elements of the crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial. And at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the 2 charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus A Juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 699-701.
So I think the defense's motive, and again, this is my speculation, the defense's motive in maybe trying to bring up that Brian pled to these counts in closing is maybe to again try to push forth, he loved her, he panicked, he felt terrible about her, what he did. So, but it doesn't make sense that you would admit to everything and any sort of medical unexplained death could have been shown to be not deliberately done by Brian Walshe had Anna just been in a condition that she could get. And I think that's the big part the defense is never going to get over. And why they maybe should have just gone with a, lesser included crime of passion, because that makes sense.
2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding in a juvenile applies with equal force. If the defense was permitted to tell the jury that he pled guilty to the two lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered any other rationale for the entrance of such evidence. And as was stated in Commonwealth versus Ferreira, 373 Mount 24, 1977 case, the jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others. Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to put evidence before the jury of his prior guilty pleas in this matter. And Madam Clerk alerted me to also file this morning 321, pause, the Commonwealth supplemental motion in limine to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped on the bench, but I'm not sure it makes a difference in light of my ruling.
It's moot at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original. It should be 318. It's my poor vision.
Okay. So just so the records.
So, Major Mom, it seems even though the defense filed at least 5 different motions on things that would be sticky or kind of tacky as far as Brian testifying, they are going to be resting. Brian is not going to be testifying. Now, it does seem a little odd that they came to this sort of decision because the judge, according to her own words, was still investigating and looking up, statutes and cases for these 5 motions that they had made for him to testify, and now those are moot. So it does seem like the defense either is sticking with the thought process that the state did not sufficiently prove first-degree premeditated murder, or that they just kind of know that this is all they got.
Clear. When I said a moment ago, I did review what the defendant filed this morning. It's just not 216, it's 318. All right. On the docket. All right, I see that I have 2 other pleadings up here, which I will address in brief. One of them I was going to address anyway, in substance, maybe not exactly as it's presented. Those are items number 319 and 320. Let me talk about 319. I haven't read it either. It's a motion to prevent the Commonwealth from basically, I believe, an Attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying he promised you something in the opening statement that he didn't deliver.
Thank you.
That's right, and after consulting with the Commonwealth this morning, they have no intention, they've told us they have no intention of doing that.
So I have already pulled out some case law on this, and where the boundaries are, and I was going to give it to you in charge conference anyway to make sure that you were aware where the boundaries are. The SJC has spoken on this issue of what's permissible and what isn't. The Commonwealth is allowed to get into it a little bit. I will alert you to those cases, and that's where I intend to draw the line as to what's permissible. I probably have them on my bench right now, but I couldn't tell you where they are. But when we get to the charge conference, I'll give those to you so you both have the benefit of my research on that issue. The other.
Okay, so the defense did try to file a preemptive motion that basically the Commonwealth can't, at their closing, say, well, you guys, the defense opening, that you would hear this, that you would hear things from Brian's own mouth. Well, the judge is kind of saying, despite the defense and Commonwealth talking to each other and assuring each other that they weren't going to do that, there are certain boundaries where the Commonwealth can go into things. And I do like that this judge, regardless of them saying they agree, she wants to be very clear and outline where those boundaries are. So if anything changes, all the lawyers know where they can go and can't go. And I do like that she's very clear about that.
Motion 320 is, I expect the defense will renew after I bring in the jury, ask you if you're going to present any evidence, and you will rest. And I'll hear you at the side of the bench with regard to that. So now, I do want to conduct the colloquy with the defendant at this point.
Would you like him sworn, Your Honor?
Hold on a second, because I'm not sure I have my colloquy with me on the bench, despite the fact that I have quite a few binders here. I think the one I need is in my office, so stay tuned. Nobody move.
Welcome to Zoom Government.
Is it better now? I unplugged and replugged, but sometimes I need to come back in and out. And she absolutely is. I love that she's, again, just putting out clear boundaries. So many of these kind of inefficiencies in courts could be, figured out if there were just clear communications of boundaries established at the beginning.
Your participant.
Awesome. So I do see two different ways to look at this. Probably likely or most likely, there really is no case that you can put on in defense here. Your defense of this client is basically holding the state to its burden to prove every element of the crime. And I do think that maybe the defense is banking on a somewhat like a Casey Anthony sort of situation, where I do think that the state has done a good job of indicating that there was a murder. But as far as the premeditation, it will all depend on what the jury sees as premeditation and how premeditation and intent is understood by the jury.
Madam Clerk. Thank you, Judge.
Mr. Walsh, if you could stand and raise your right hand, please. Do you solemnly swear or affirm the testimony you shall give in the cause now in hearing shall be the truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing? So help you God.
I do.
Thank you.
Excuse me.
You can be seated. I just didn't, was wondering if you were asking me if I wanted him over on the witness stand. I do not.
No, I believe the jury is in now.
Mr. Walsh, one important
Yes,
decision
the
that all
jury is
defendants
gone.
in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you. That is the right to ask you questions. If you do not testify, and you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may know your decision not to testify. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing?
Whether I'll testify or not in my trial.
Right? Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor. I find that the defendant, Brian Walsh, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences. I accept his decision. We can bring the jury in.
Yeah, I kind of would have liked to have heard the "I was the greatest husband ever." No. I don't know. I will say I am the type A person that this has annoyed me. The fact that, the defense has basically wasted an entire day. I'm the type that let's get the closings done, let's get the jury off to the verdict, and let's finish this, before the weekend. Now the jury's going to have to be deliberating on a Friday afternoon or evening because, Grandpa Simpson is going to take like 3.5 hours on his closing.
Jurors entering. Hear ye, hear ye, hear ye. All persons have anything to do with the Honorable Diane Frenette, Justice of the Norfolk Superior Court, for your attention, you may be heard. Once you have a call from Massachusetts in this Honorable Court, please be seated. Please turn off your cell phone.
Morning, jurors. Morning. Jurors, we'll start today with the 4 questions. Jurors, were you able to comply with my order that you not speak to anyone about this case?
Yes.
Yes. Were you able to comply with my order that you not do any research about the case?
Yes.
Were you able to comply with my order that you not go on any social media or access any news media? Yes. And you still all have open minds?
Yes.
With those 4 questions all answered
All right.
in the affirmative.
We are taking a break because I have figured out who the bailiff looks like because it's been bothering me. Now, I know I've already said the Zodiac, which I still contend is rather accurate. But if you were ever watching, and this used to be one of my favorite cartoons, Life with Louie, great cartoon. Much more adult than I realized it was. But he looks exactly like the dad on Life with Louie. Thank you for taking this little bit of ADHD, train sidetrack. But that's who I was like. I was like, who does this bailiff remind me of? And I finally figured out it was the dad on Life with Louie cartoon. So if you are a niche 90s baby cartoon addict, there you go. I hope you feel seen, all one of you on the internet who will watch that show too.
Affirmative, we're ready to begin today's work. Does the defense wish to call any witnesses in this case?
We do not, Judge.
Defense rests?
Defense rests.
All right. I'll see counsel at the side of the bench. The jurors, I think I've referred to the trial as I sort of see it as different chapters of the book. And another chapter of the book has just closed. And that is that all the evidence in the case has now been presented.
Paula, you've actually missed quite a bit, but not too terribly much. I know that sounds a bit contradictory. It seems that despite putting in several motions that were going to curtail issues that the Commonwealth could bring up in Brian Walsh's testimony, the defense has decided to rest. Now, this looks like it was a decision made either over the night or late in the night, because the judge was this prior evening looking up those 5 issues. However, today, the defense has decided that they're not going to put on a case. Brian and the judge had the talk where he did say that, he wasn't on booze or any of the devil's lettuce. He had talked to his lawyers, and this was his choice to not testify. So we've gotten the jury in, and basically the case is going to be closed now. And then tomorrow we are going to be getting closing arguments. So quite a lot has happened, but not very much. Now, there was a ruling that the judge reiterated about the Commonwealth and the defense not being able to bring up that Brian had pled guilty to the lesser charges in this case. And there was also something, basically, the Commonwealth is allowed to, with some caveats, and the judge looked up the statutes and case law for it. But basically, the Commonwealth, should they choose to, in their closing, go into the fact that Brian Walsh's defense in their opening statement promised that we would be hearing from Brian Walsh. They can go into that. Now, the defense and Commonwealth, both the attorneys said that that wouldn't be an issue that either were touching upon. But I do like this judge in that she is going to, during their jury instruction time, go over the parameters that she will allow should that change. So that's kind of where we are. The jury has come in right now, and then she's going to kind of explain what we're looking at as far as their schedule upcoming tomorrow.
Presented to you. I remind you at this time, jurors, and I reminded you of this at the close of yesterday, the defense has no burden in this case and has no burden to produce any evidence at all. And that's because, as you probably are all very well aware at this point, the burden lies on the Commonwealth to prove its case beyond a reasonable doubt, and it never shifts from the Commonwealth. All right? So what happens next? What happens next is the next chapter we're going toward your deliberations is that really two things that happens interspersed. I'll explain. The two things that need left to be done is I need to give you my jury charge, my legal instructions to you. And then you need to hear the closing arguments of counsel, right? So the way that happens is I will give you, when we next reconvene, which is going to be tomorrow morning, and I'll tell you why in a minute. I will give you instructions on the law that's specific to the charge that's primed here, the charge that the crime that is charged here. Excuse me.
Tammy, normally I would say no, but the kids are out of school today, pending craziness, and I don't know if they got into all the sugar or what, but they are going stir crazy. So I'm actually kind of okay with it being a shorter day.
Then the lawyers will do their closing arguments. And then I come back and give you additional instructions. I call them more generalized instructions. So those two parts of the trial happen interspersed. A little instruction, argument, more instruction. That's going to happen tomorrow morning. And I try to be as transparent as I can in my cases. The reason for that is I don't just pull these instructions out of the ether, as you might imagine. There are instructions and guide instructions. And there, I get the input from the lawyers about what they're seeing. And that hasn't happened yet because we've moved at a pretty efficient pace. So I need to do that work with the lawyers today, and I will. And that's what we'll be doing today.
I very much love that she's taking time to explain to the jury. Again, if you're not kind of one of us rare people that find it very fascinating to watch jury trials, all of this is a bit like trying to read Greek and Chinese and you're dyslexic and you don't know Greek or Chinese. So I do like that she really explains all of this, okay, there's a reason that we're doing this. I know you're probably wondering why we're not just going to the next part. And, kind of taking away that mystery so the jury isn't tempted to look at stuff, because it can be really kind of confusing. Like, hey, well, why are we not just going to the next part? Or why aren't we just doing this? So I think that it's really great that she is doing the things and explaining all of this, because it really is a whole different kind of procedural outlook. And it gets kind of easy for us to understand because we're in it a lot and we watch trials all the time, but it can be absolutely confusing if you're just starting to watch trials or if this is the first time you've ever been in a court as a juror.
What we're doing today is getting some rest and some sleep so you can be all rested for tomorrow morning. And I remind you, jurors, I'm going to send you off for the day. I remind you what I just checked in with you. I'm counting on you to be obedient to those rules right to the end, right? Jurors, don't speak to anyone about this case. Don't do any research about this case. Stay off of any social media, news media, and continue to have open minds as we finish these last chapters of this trial. Have a great day.
All rise for court, please. Jurors, close your notebooks and follow me.
Okay, so it does look like we're getting a little bit of the charging, or at least them going into that, but it doesn't look like other trials. It seems like we do get to be around when they discuss charging documents, but it doesn't look like there will be any, at least right now.
Thank you.
Yesterday at the side of the bench, we had a discussion about, during Mr. Mootlu's testimony, in which I asked that a certain document be marked as, I think it was M or N for identification, Madam Clerk, which was it?
N, I believe, the hammer?
No,
Oh, the other one was N, Your Honor.
N for identification. Has that been done? This is a question to the defense. On cross,
Page 53 of that transcript.
I want that
Your
whole
Honor.
document to be marked for identification. Has that been done?
Okay, I'll get that to the court this morning.
And just so the record is clear, as I understand it, that is a multi-page document of which Mr. Mootlu was asked to review a single page of a record of his police interview. Is that correct?
That's correct, Your Honor.
Are the parties ready to do the charge conference, recognizing that I haven't given you a draft yet because of the way things played out? I did stay last night and draft the jury instructions with the benefit of two things so far that I considered, or at least three things. One was what I had marked for identification the other day, which is the first 2 pages of the model homicide instructions. I'd asked each of the parties to mark up, so to speak, those 2 pages of the SJC's model instructions.
Okay, so that was the 2 pages that she kept bringing up, referencing and asking if they got those 2 pages in. And that's kind of what I was leaning toward, thinking that this was in service of, working on jury instruction or charging documents. I guess they're different terms of art, but similar things, kind of like Commonwealth and state. But that does make sense. This judge has seemed to be very, very willing to collaborate and listen to input from both sides, and then go to the statutes and what, is proper, and then come back with something that, seems to try to appease as much as she can both sides with the statutes. So I really have been impressed with this judge, and I hope she does more trials in the future.
And so you did at my request, and I had the benefit of that information. I also received yesterday, Madam Clerk, if you could get me while I'm talking, the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I had that. I considered that as I was drafting the draft instructions yesterday, and I'll talk to you about that. What I didn't do, and I sort of made a mental, because I ran out of steam, frankly, yesterday. I know that very early in the case, before the case started, pleadings with regard to jury instructions, and I made a mental note to go back to those this morning, but I didn't, frankly, have a chance to do that since it is unfolding a little differently than I expected at the end of yesterday. So I tell that to you so that you know that if there's something that you wrote in there that's still relevant now, it might still be, that I don't have that fresh in mind, all right?
Yes, Your Honor.
So, said more bluntly, if there's something in that I don't go over now that you want to persist with, just...
Your Honor, there is actually, with respect to the consciousness of guilt instruction, potentially. I don't know if it would make sense to take a brief break so that I could collect my notes on that topic.
All right. I will take a brief break before we, and what I'm going to intend is this. The draft instructions as I have them right now includes what I tried to do is, when I was scratching my head, saying to myself, why do they want this instruction in? I put it in anyway, and then I put it in italics, so that should be your clue that I'm questioning either why this is in here. For instance, the object of the killing must be a human being that the defense has asked for. Question mark, why are they asking for that? So the italics either means you asked for it, I'm questioning why you want it, be prepared to answer that question. Or
I love this judge. Again, she is doing things exactly the way I would do it. But I like that she's kind of really making the lawyers, especially the defense, let's be real, the defense. This is only to the defense. Like, why are you asking that, the jury find that Anna Walshe was a human being? That's one of the elements you want satisfied. I like this judge in that she doesn't, question the judgment, but wants you to have an argument, a case, and, laws and statutes that are going to actually support you.
in the instance of the instruction, I have instructions drafted right now and this is in part 2 of the instructions. Impeachment by prior conviction, impeachment by prior inconsistent statement, and impeachment by prior bad act. And in particular, in the prior bad act, I took a swing at attempting to fairly describe the evidence that's been presented to the jury with regard to the defendant's bad acts. I tried to do it neutrally, but there may be other words that you like better. So those are in italics, even though the whole instruction isn't in italics. Who's closing for the defense?
I am.
Damn
And
it.
who's closing for the Commonwealth?
Oh, God, it's going to be a battle between ASMR voice, pure Colombian uncut ASMR voice that's going to make us fall asleep, and Grandpa Simpson tilting at windmills. Well, to give us hope in this very dark circumstance, I have created, now where did I put it? For the love of Lemmy, you know what? I have created for our entertainment tomorrow, given our choices between sleeping and crying or getting earbuds, and earplugs, not earbuds, a closing bingo for Walshe. And I even added pictures, so we have our favorite judge, Mommy Dearest, if she actually gets mentioned. We have Brian at the Home Depot. We've got the ring. There is a Porsche. We do have a bunch of stuff, so it will be an interesting time because honestly, what the hell is this defense? You are pushing at the very last of my patience. She likes the smell of leather.
The address of the refuse center, 300 Forest Street, Peabody.
Yes, Your Honor.
the defense now seeking the instruction with regard to the defendant's right not to testify.
Yes, Your Honor.
I'll add it. Commonwealth seeking a mode of instruction.
Yes, Your Honor.
Again, look for the highlighted language in the consciousness of guilt instruction and see if there's some other language you would prefer that adequately captures trial evidence. All right, let me propose this. I'm going to make those edits and additions based on the information that you just provided. And then I'm going to have Madam Clerk shoot you a copy of the draft instructions. And I know you probably want to be spending your afternoons working on the closing arguments. So I think it would be reasonable, given what I think is relative to other cases, the instructions are pretty straightforward. By that I mean there also was a lot of agreement with regard to your submissions as to what you wanted in these instructions. And so it's for the second half of the instructions that the special instructions. I will go back and look at what the Commonwealth submitted early on in the case. Should I presume that everything you wrote then you're still pursuing today? 88 Cusick.
Yes, Your Honor. The Commonwealth was seeking a direct and circumstantial evidence instruction, a consciousness of guilt from the MCLE instructions, and an expert witness instruction.
All of those instructions are presently in the charge, in the draft charge. So thank you, because that prevents me from trying to find out where it is.
Yes, Your Honor. It's under general instructions at the back of the pleading, the preliminary request for jury instructions, and we just provided the name of the instruction from MCLE.
All right. I don't know if I probably grabbed it. I'm not a huge consumer of the MCLE instructions. I usually use other sources, but you can see what I came up with, and you can tell me whether you disagree with it. But we talked about the consciousness of guilt instruction, and it does not, I've never given, as far as I recall, a version that put my thumb on the weight of the evidence. So it presently either says you've heard evidence suggesting, what page is it on? Hold on, it's on page 27. Yeah, it's some evidence suggesting. I've never.
And I do really think that this case, they kind of just go after this. I do think that this case is going to come down to the jury and what they think happened in that house, and how what the elements for first degree premeditated murder are in Massachusetts, because I can see it both ways. I can see that, the jury is going to, basically walk out, put the, guilty and walk right back in 15 minutes. But I can also see that that there is, some question as to whether this was a act of passion. Brian found out about the affair. Maybe Anna snapped and she just said, I need you to grow up, and I'm looking at moving on, and he snapped. I I don't know. I think there's plenty in there to infer or to, come up with the reasonable idea that whatever happened to Anna in that house was not a sudden, unexplained, medically explainable, like heart attack, aneurysm, aortic dissection. I think that's clear. But whether this was something he had been planning for a while or this was a heat of the moment thing, I don't know, and the state didn't really tell me. Now, I do believe that Brian was aware of he was aware something was going on. And I think that you can make that statement based on just evidence that came from the trial because he was looking up William Fastow on the 25th or Christmas Day of the year that the incident happened. Well, New Year. So I do think that there are ways that you can infer that he knew about William or maybe had an inkling. Do I think that the motive was a combination of many things, of her wanting to take the boys, Brian possibly looking at one of the primary reasons for him getting a lenient sentence in the federal case falling apart if Anna took the boys? Anna was in a stable place. Everything was in her name if she moved into the DC home. And I think Brian had for years and years presented himself as the provider, as the, financial head. You could tell that even the defense attorney was very kind of almost irritated on Brian's behalf that Jeff, the witness from yesterday, didn't include Brian in any talks about real estate investment. The defense made a big point like, well, Brian was going to look into investments. Brian was broke. His entire job had always been conning people. And once that broke down, he was broke. And I do think that for a man who is very insecure, doesn't have his own sort of self-worth, when that financial sort of facade is crumbling and your wife now is essentially succeeding without him, I think that was an attack on everything he kind of saw himself as. But that's just me playing detective, and it will depend on, the life experiences of the jury members, whether they think that Brian's, the defense's whatever they're going to throw to the wall is worth listening to, if they think that the state did enough to prove their case. It will be interesting to see that. I am going to be interested in the state's closing. I did not like the Commonwealth's the Commonwealth did a fairly good trial, but they didn't really tie this case together. They didn't really have sort of people in sort of, and I do understand scheduling. I do like the trials where they try to put things sort of in chronological order or in some kind of logical order. And I don't think that the Commonwealth really did that this time. And maybe it was a case where it wasn't required. Maybe, the fact that they have just basically all the evidence, they figure they're good to go. I don't know. We will wait and see. I will be starting tomorrow at 10:30. Do remember that Shizzy and I have Friday wrap up, so it will be crazy time. Mornings with Mo. We will have another, headline news house rock song. Pray for our souls now and at the hour of our publishing those. So we will be hanging out. I will have bingo ready to go for tomorrow for closing. I have some Code Blue Cam videos picked out for Verdict Watch. And just a little reminder on Verdict Watch, if it does take over the weekend, if, it doesn't come back right away, do keep in mind and remember that while we, at the end of the day, at the end of our trial stream and through it, get to kind of decompress from all the utter ridiculousness that this case has been every day, they have not been allowed to talk about this. So they might just spend a good hour decompressing and getting over this. I mean, I'm sure it was very different to be in the room and actually watch them open some of those pieces of evidence and see some of those pictures firsthand. So I can only imagine that maybe they will need a little bit of time to kind of decompress and go over their notes. I will say that I have nearly filled an entire legal notebook front and back just with my notes. So let's give the jury some grace. I know those of us who have been following it might feel like we know he's all the guilty or it's going to come back really soon, but they are just now getting to talk about all this and they probably have a gajillion and 12 notes to get over. So we have plenty of cop cams. It's not like we don't have enough crazy things and getting arrested that we can't watch. So we will be hanging out together for that. And then if you guys know of an upcoming trial you want to watch, the only thing I ask this close to Christmas is please not a kiddo trial. I'm not going to be doing any of those before Christmas. But if you know of an upcoming trial that you would like to watch or anything like that, let me know, because the Petty Express, this does seem to be kind of a workable schedule for me, the kind of 10:30 to 2, 3. So we will continue to be doing trials on the Petty Express and going forward. So if you have any suggestions, if you're on the replay crew, put them in the comments or, let me know in other comments and other videos. You know how to get a hold of me, y'all. I'm not hard to find. I am going to go make sure that the ferals are not burning down the house, or at least that all fires are remaining in the fireplace. So thank you guys so much for hanging out with me on the Petty Express today. I am not liking the defense's move here. I do not like... I do say as a juror, I would feel upset if the opening statement of the defense was that I was going to hear from the jackass's own mouth what happened, and then he decided not to testify. I would feel like Brian was gaming the system again, and that he was kind of disrespecting both my time and my intelligence, but I tend to have a shorter fuse than other people, so there you go. I will see you guys tomorrow. Stay warm, stay safe, and, well, keep a can of bitch fire just in case you get a little cold. I will see you guys tomorrow. Bye.